Another big day on Parliament Hill this morning. While MPs sat in the House of Commons in a standoff over the SNC-Lavalin controversy, Jane Philpott's first interview since resigning from the Prime Minister's cabinet was published in Maclean's. The headline? This quote from the former Liberal minister: "There's much more to the story that should be told." She goes on to say in the interview, "I believe we actually owe it to Canadians as politicians to ensure that they have the truth. There's been an attempt to shut down the story. I have to hope that people, my colleagues in particular, can believe that I'm not trying to damage our party or our government." Both Philpott and Jody Wilson-Raybould resigned from cabinet over the SNC-Lavalin affair, and the Conservatives say the Prime Minister should waive all privilege on the issue so the two women can speak freely about it. For more on how all of that is unfolding, I'm joined by the CBC's Katie Simpson. Hey, Katie.
Hi.
Earlier today, the Prime Minister responded directly to what Ms. Philpott was saying, Dr. Philpott was saying in this article. What did he say?
Well, the big question is, how can Jane Philpott as well as Jody Wilson-Raybould, after the repeated comments that they have made questioning the Prime Minister's confidence, how can they remain in cabinet? And it does
Caucus,
the caucus, pardon me, not cabinet, caucus. And how can they continue to be a part of this Liberal team when these comments that they are making publicly are damaging the Liberal team? The Prime Minister was asked about that today, and there is no change in his position. He is still welcoming them to remain a part of the team heading into the 2019 fall election.
One of the things that has always been a strength of the Liberal Party of Canada, and certainly has been a contrast from the way that Stephen Harper and the Conservatives managed their government, managed their caucus, managed their approach to democracy, is we recognize that a diversity of perspectives, of experiences, of opinions is extraordinarily important if we're going to fully reflect the extraordinary diversity of Canadians.
The Prime Minister was also asked again whether there's going to be any further waiving of privilege. Jody Wilson-Raybould has said, and Jane Philpott have both said that given the restrictions around what they can and can't say due to whether it's a solicitor-client privilege or cabinet confidentiality rules, that they can't speak fully. The Prime Minister was asked again today, and of course this is what the vote in the House of Commons is so much about, the Conservatives pushing for the government to waive any sort of rules around this. He was asked about that again today, and it's clear that he's not budging from that position. It looks, at least at this point, like he won't be changing any of the rules around that.
Yeah, it's like there's two sort of sides to the big question. There's the question over whether or not they can and they will speak further, whether the government has to waive that right or they have it on themselves, or whether this whole caucus idea. And I know you spoke to other MPs, and our colleagues have on the Hill today, Liberal MPs, about how they feel about them remaining in caucus, particularly given what we heard via the Maclean's article this morning.
Yes, and the big question still remains, why are they not speaking, or why are there options available, avenues available to them for them to have a public conversation to give Canadians the answers they want to this? And that is a question that is now being raised by at least one Liberal MP publicly. Listen to Judy Scrow talk to our colleagues on Parliament Hill today about what she thinks needs to happen next in this situation.
There's no reason that Jane or Jody cannot go into the House of Commons, parliamentary privilege, talk for as long as they want, say anything they want. They'll be clear of any, excuse me, cabinet issues. Parliamentary privilege is in the House of Commons, and there's absolutely no reason that the two former ministers can't do that.
She's essentially arguing it's time to rip the Band-Aid off. If there's more to say, say it, and go and say it inside the House of Commons where there is parliamentary privilege. Now, there's a range of legal opinions on that, whether that is something that can be done, and I know you're going to have a legal conversation about that in a little bit. But we also asked some of their Liberal MPs, some of their colleagues, are they concerned about the drip, 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 the slow drip from this story and how it's having an impact on the party? Longtime Liberal MP John McKay gave a pretty blunt assessment of how it's been affecting the party.
I think that, members are starting to realize that this has political consequences, and the decisions that have been made by both of them over the last few weeks have hurt members, and there are political consequences, and it's one thing to take a hit from the opposition or circumstances beyond caucus or cabinet. It's another thing to take political hits from your own people.
Other MPs that we did speak with defended Jody Wilson-Raybould as well as Jane Philpott, saying they are welcome in caucus as long as they continue to stand up for the Liberals in the 2019 election.
Certainly something to watch. Thanks, Katie. The CBC's Katie Simpson. Can they or can't they speak? That's the big question on Parliament Hill today. Both Jody Wilson-Raybould and Jane Philpott have indicated they have more to say about the SNC-Lavalin controversy. And right now, MPs are in their 23rd hour of a parliamentary standoff over the issue. So does the Prime Minister need to waive all privilege for the former two cabinet ministers, or could they legally say what they want? Rob Walsh is a former law clerk of the House of Commons, and he joins me now in studio. Hi, Mr. Walsh. Pleasure to have you here.
Pleasure to be here.
Thank you very much for coming in. So the crux of what we've been hearing over the past little while, and especially this morning in Jane Philpott's interview, is that they can't speak, her and Jody Wilson-Raybould. Their interpretation is that there is that waiver that the Prime Minister granted doesn't afford them the opportunity to speak about the time after which Jody Wilson-Raybould left her position as Attorney General. From your point of view, is there anything that prevents them from doing so?
It all depends on where they're doing it. If they're speaking in the House or in a committee proceeding, they are absolutely protected by the law of parliamentary privilege, and no legal proceedings of any kind can be brought against them based on what they say in the House or in those committee proceedings. So in my view, they are totally at liberty to say whatever they want in the House or in appearing before a committee.
No matter what they're talking about, even if, for example, it brings in the SNC-Lavalin criminal case?
Doesn't matter what it is. The right is absolute. It goes back to 1689, if you would believe it, when the Bill of Rights of the UK was established. And the Supreme Court of Canada has recognized the Bill of Rights of 1689 as being part of the constitutional firmament of Canada. And in that Bill of Rights, which a number of provisions, but one in particular said the courts have no jurisdiction in respect of matters said in Parliament, and that includes committees.
Has that been tested?
Yeah, I can give you a number of cases, but one, for example, was, and it's not just court proceedings. There was, back in my time, and I can't remember what year it was, there was a big stink about RCMP pensions, and the Deputy Commissioner spoke to a committee, testified in front of the committee, and the committee didn't like what she said, thought she was lying, said she was lying and whatnot. Anyways, the RCMP itself took disciplinary proceedings against her based on what she had said in the committee and it being untruthful. And that went to federal court, and the federal court threw it out. You cannot base anything on what was said in the House or in committee. All right? And this is not a court proceeding, this is an internal disciplinary proceeding by the RCMP. All right? So even the Bar Society or the Law Society can't start its proceedings. They're exercising a legal power, after all. They can't start a legal proceeding against Ms. Philpott or Ms. Wilson-Raybould as lawyers on the basis that they breached solicitor-client privilege or whatever. If they're talking in the House or in a committee, that's untouchable.
So let me break those down into two things, because the committee, there's still debate, discussion over whether or not they'll be called before another one. We know that they won't be called before the Justice Committee right now. In the House, what mechanisms do they have to stand up and talk?
Well, it gets a little tricky in the House in terms of getting the floor. Members don't have the right to just rise when they feel like it and take the floor for any length of time. There is, as you may well know, it's not that you pay a lot of attention to it, but the so-called Standing Order 31, where private members get to stand up and say what they want for 1 minute, just before question period, the 15 minutes before question period. Well, 1 minute may not be enough for either of them. And secondly, those getting on the list of your party to say something is controlled, I think, by the caucuses. And so they would probably be so far down the list that it wouldn't, it'd be a long time. We wouldn't perhaps have the same interest anymore. Well, there are a few other procedural games one might play, but it'll be hard for
So, for example, if they had 30 minutes worth of things to say, is that possible to do within the House?
Well, if a bill was under debate in the House and the subject matter of the bill touched on what they wanted to talk about, there's a 20-minute speech that's given to members in debate. So when their turn comes up to debate, they get up, they could use their 20 minutes. But again, the parties control the series of which members speak on the bill, and she may find herself either at the unreasonable hour of the day or weeks and weeks down the road.
And the difference between speaking within the House and outside, I know parliamentary privilege, but that's not something everybody understands, right? So if they were, could there be consequences, for example, for them speaking outside the House in that where it pertains to that period?
Right, leaving parliamentary privilege out of the picture, and they're talking somewhere else. Mm-hmm. There are two possible statutory provisions. I don't think either one of them would ever be applied. One is Section 122 of the Criminal Code, which is basically a fraud or breach of trust. So it's a criminal offense to commit a breach of trust. Well, speaking about a cabinet confidentiality publicly, is that a breach of trust? Possibly. I don't know. But can you imagine the trial that would produce? That would make the Duffy trial look like a playpen. That would be an unbelievable trial, as the government is prosecuting one of its former cabinet ministers about what was said in cabinet. Because the first question is what she said a matter of cabinet confidence? Well, was the cabinet talking about this? Really? What were they talking about? So that'd be a messy thing for the government to advance. The other alternative is Section 4 of the Security of Information Act, which makes it an offense for anybody in the possession of secret information or codes or whatever to share it with a third party. That generally is directed at, the world of spies and terrorists or whatever, but it's not meant. My view, cabinet confidentiality is only enforceable as a practical matter toward those members of cabinet who are still members of cabinet, because if they breach it, they're thrown out.
So is that the only enforcement?
Really, when you're no longer a cabinet minister, what's the downside? Well, the downside is she might get thrown out of her caucus. She might be thrown out of the Liberal caucus. But as a practical matter, I don't see there being any significant legal threat or impediment.
In the Maclean's piece, Jane Philpott, for example, said that she swore an oath. She referred to that as sort of a concern where cabinet confidence was concerned. Does that mean anything? Does that have anything?
Sure, it has moral value. She's to be commended for being concerned about, the oaths she may have taken, and that's fine. But the question, as I understand you're putting it, is whether there are legal consequences were she to talk in the House. I'm saying there are no legal consequences to what she said in the House. Her fellow Liberals may not think much of her. Her fellow cabinet members may not think much of her. General public may not think much of her. Who knows? But legally, what she says in the House stands.
Is there any difference between the position she's in and the position Jody Wilson-Raybould is in, given that Jody Wilson-Raybould was Attorney General?
Well, no, I don't think so. In either case, they're members of cabinet. And cabinet confidentiality applies to both of them in the same respects, and what they say in the House is equally protected. But once you get outside the House and start talking like that, then that's a different game. And I still don't think either the 122 of the Criminal Code or Section 4 of the Security of Information Act would be prosecuted against them. Just imagine what that would produce in the way of a trial. I mean,
and those are the only legal consequences
so.
that you perceive for breaking cabinet confidence or coming outside of that waiver.
Yeah. Now, Ms. Philpott, she's a lawyer, is she?
No, she's a doctor.
Oh, she's a doctor. Correct. Sorry, my respects, Ms. Philpott. I should have known that.
That's okay.
Madame Wilson-Raybould's a lawyer.
Yes.
So whether she's a BC lawyer. So whether the Law Society of BC could take proceedings against her for breaching confidentiality, because generally lawyers are governed by sister and client privilege, which means they got to respect the privacy of their client, and whatever the client tells them is private to the client. But there's also, quite apart from sister and client, there's a general obligation to be confidential, to respect to treat what you learn from your client as confidential. Sister and client, that privilege really only applies in court. You can't be compelled to testify about what your client told you, okay? But confidentiality is a general ethical requirement of all lawyers with respect to the business of their clients. And if you were to breach confidentiality, the Law Society might come at you in unprofessional conduct or something like that. But that's the nature of a legal proceeding. But if it's based on what was said in the House or committee, no, they can't do it.
Okay.
But if you do that in the local bar,
okay, and so if I just want to make sure I'm clear and our viewers are clear. Basically, your feeling is they could stand up in the House or at committee with impunity, without fearing punishment. It would be difficult to do so in the House. The mechanism would be hard. They can't stand up anywhere outside, but even if they did, you doubt the punishment would be applied.
I doubt that the legal
ramifications.
Because you're talking about a criminal charge and a trial and all that. Well, the Director of Public Prosecutions, who has responsibility for the SNC affair, might be asked to consider whether to lay a charge against her former boss.
And round it goes.
Attorney General and around.
All right, I'll leave it there. Thank you, Mr. Walsh. Very much appreciate your help.
My pleasure.
So why are both Jody Wilson-Raybould and Jane Philpott staying mum, and why won't the government just extend that waiver beyond the original one that they issued? It's time for the Power Panel to weigh in. In Toronto, Supriya Dwivedi, host of Global News Radio, Toronto's 640 AM's morning show. Alongside her is Melissa Lantzman of Hill & Knowlton Strategies. Here in studio with me, Counsel Public Affairs Brad Levine, and of course, as we mentioned, senior writer at Maclean's, Paul Wells, the journalist behind today's latest twist in the SNC-Lavalin saga. Paul, thanks for being with us.
Oh, slow day.
Yeah, very slow day, thanks to you. I think I woke up at like 5 and read your article right away. Tell us as much as you can about how it came to be and what you think it says.
So within an hour after Jane Philpott quit cabinet, I texted her and said we should talk. And she promised to talk immediately and then was really not in a mood to give interviews. And 2 weeks later, she was in a better mood. We didn't negotiate timing beyond that. She was available to speak on Tuesday morning as I was headed into the day-long budget lockup. She asked that we not run the interview until after the next day's caucus meetings, until after Wednesday's caucus meetings, because she didn't want her colleagues reading that interview on their way into the meeting, and I was happy to oblige. It's not infrequent that reporters discuss the timing of publication with interview subjects. She was in a sour mood. She understood that people were mad at her and that they would be angrier the more she spoke. But she had decided that having resigned from cabinet, she had to give a fuller explanation of why she did. And having seen the Liberal majority on the Justice Committee essentially put an end to that investigation, she had to repeat her belief that Canadians are owed fuller explanations of how this government handled the SNC file. And the rest of it is there for people to read.
Yeah, and you posted it. It was interesting because it wasn't really an article. It was the transcript, basically, of your Q&A.
This is a crazy habit we have at Maclean's. If people talk to us, we run substantially everything they said and let people decide what's important.
So, Brad, the debate then that took place after that today is, can they or can't they speak, essentially? You've got one camp saying they can just rise in Parliament. They can go in the House before a committee. They can say whatever they want with impunity. The other camp saying, well, obviously they interpret the waiver as Paul's article pointed out, or as Jane Philpott said in the article, that it doesn't extend to them. After the period after which Jody Wilson-Raybould left her post as Attorney General.
Yeah, and are those SO31s, those statements before question period, are those adequate? I would submit no, they're not. They're short. They're, what are they, 60 seconds, 90 seconds? Those are just for MPs to rise and offer greetings or talk about things that are going on in their riding. Those are not for clearing the air on something that happened. But I think what the interview makes clear is that there is more that needs to come out in this SNC affair. The Liberals at Justice shut down the Justice and said, we've got enough information, people can make up their own minds, come to their own conclusions, is the way it was put. I think that what Ms. Philpott said in Paul's article puts a lie to that. That is, there is way more information that Canadians need to find out. So whether or not we extend that privilege so that they can speak, whether the committee comes back, or whether we have a public inquiry, the idea that the Liberals have put a lid on this file, I think, is sorely missed by the Liberals today.
Supriya, I mean, she was explicit in Paul's piece and said that she believed they were shutting it down. Do you think that is damaging politically to the government?
Yeah, I mean, I think for anybody that's been following this along, certainly the optics of having a majority on the committee vote it down wasn't great, and I do think that there are now basically two camps across this country in which you either are a diehard partisan or a diehard fan of this government, and you don't think there's anything untoward here, or you are thinking that this doesn't really pass the smell test, even if you're not necessarily a fan of the either opposition leaders or either opposition parties. And I think, to Dr. Philpott's point in the interview with Paul there, I can certainly understand from her perspective that I think, and Paul, correct me, but it was I'm paraphrasing, but she put some line as all of the legal experts could all say that she can speak, she still wouldn't consider that matter settled. Yeah, right, exactly. So, except it is sort of settled. And to Brad's point, yeah, it may not be the best venue to air grievances Festivus style, but I think ultimately, if there's no other option, then why not go ahead and do that? I also think it's somewhat weird and cagey to be saying, well, there's more to come, except I can't really speak, except there's more to come. So it's like, well, okay, well, if you can't speak, then how do you, but there's more to come. It's just like, just let it out already. I think we just need full Festivus style, let it all hang out, and then Canadians can ultimately decide.
Melissa, does Supriya have a point there that we keep hearing, well, there is more to say, there is more to this story, but we can't say it. Does that seem at all disingenuous?
Look, the Liberals have said for a long time now, I think we're in our 7th week, that there's nothing to hide, so why don't they just waive the privilege? Obviously, the two women, Jane Philpott, Jody Wilson-Raybould, feel that the House is not the right place to do that, so it's incumbent on the government to waive the privilege. Like, we've been talking about this now all day. You know what we haven't been talking about? A $20 billion deficit that they sort of put forward. We've been talking about nothing around the budget, so the government didn't change the channel, and I think this is a real crisis in leadership leadership. I think there's probably some divisions in caucus, and I don't actually see how a prime minister could keep her in there.
Paul, when she said on the question of what legal opinions and that kind of thing, why was she uncomfortable, even if all legal opinions were saying you can do this?
We didn't go into that. I'm not clear on that. She did say that she's been getting legal advice, and I didn't ask who her lawyer is, but she's like everyone else, she's lawyered up. Right. She probably doesn't have a former Supreme Court justice advising her because there's only so many in the country, and the rest
they're busy on other government projects.
They're busy representing other people.
But it was great to hear Rob Walsh, the former clerk of the House. He's so plain-spoken and so wonderful. But he said, as a practical matter, the only thing that can bind a minister to cabinet solidarity is if they're still in the cabinet. I humbly submit, I reread the three oaths that she took when she became a privy councillor and a cabinet minister. She swore an oath to God that she would keep cabinet secrets secret. And Jane Philpott is the kind of person who takes that sort of thing very seriously. And she said that she swore an oath that she would serve the Queen as a faithful servant should. That implies constitutional responsibility. And I believe that she would hold that oath seriously, even if there weren't practical
legal
ramifications for.
That's interesting.
You know, I believe that she takes oaths seriously.
But then would a waiver from the Prime Minister have to, directly address the oath?
That's the Crown and Council. That's essentially the Queen letting her off the hook, constitutionally, and then she would be free. This is my pure speculation.
But that's interesting because we had all been asking all day, like, you know what I mean? If you can say something in Parliament, if you are getting legal advice, that you can talk about.
I used to try and figure out Stephen Harper by going back and reading a few fundamental texts. I think with Jane Philpott, the texts that are interesting are the oaths that she swore and the ethical and responsible government handbook that the Prime Minister and the clerk told every cabinet minister to take to heart. And that handbook is very clear about what is proper in terms of the AG's role in a criminal prosecution.
Brad, so, I mean, then it goes to the question of if the government, like I think Melissa was saying, if there is nothing to hide, and we kept hearing that. I mean, the government's answer today, and the Prime Minister specifically, was this waiver was unprecedented. Though we already granted it, it already is unprecedented, and didn't really specifically address the idea of extending it. Is that enough of an explanation?
No. I think that half measure to give that very tight timeline of a waiver, that only the time that she was Attorney General and not afterwards, left a lot of questions unanswered. A lot of there's a lot of
one big question: why did Jody Wilson-Raybould resign?
Well,
that's the big one.
And there's so many questions that are still outstanding. I just want to pick up on one of Paul's points. One of the things that was in the interview that I found really interesting was that when she was talking about how people within the senior ranks of the Liberal Party had often conflated the best interest of the Liberal Party and the best interest of Canadians being synonymous. I'm paraphrasing, but that was the general gist. And I think that speaks to one of the big challenges that Trudeau has. He is not in control, communications-wise, of this issue. I don't think he's ever been in control of it. He's certainly not in control of it this week, and it's week 7 or 8. But this notion of the arrogance, that's one of the I think the real challenges that the Liberal Party in this country have as being arrogant, maybe being above the rules, above the law, looking out for friends and insiders. And there's Dr. Philpott speaking directly to that point.
She basically said that was part of the reason why she ended up doing what she did. She got this advice from someone, right, in your article. And what she said was, this is someone who's been around politics for a long time. They said that politicians in general, and perhaps Liberals in particular, make mistakes when they assume that the best interests of Canadians and their own future political success are synonymous. Yeah. Sabrina, what did you think of that?
Yeah, I mean, I thought that was quite telling, and I mean, I'm not going to disagree with Brad. I think it's well known that one of the major Achilles heels for the Liberal brand, TM, is basically arrogance, right? And I think that's one of the things that was appealing about the Prime Minister's campaign when he was then just third-party leader, was that it was like, this isn't going to be your dad's Liberal Party. This is going to be an all-new Liberal Party, and we're going to do things differently. You know, politics are going to be different, and I think that's what got a lot of millennials, even older millennials like myself, sort of off the couch to really rally around this government. So I do understand that being a point here. The one thing I will say, though, and Melissa sort of touched on it, is that I don't know how they go on, Dr. Philpott and Ms. Wilson-Raybould, sitting in caucus. And I mean, I think the last time I was on the show, the analogy I used was the '96 Bulls, and like Pippen and Rodman were part of the team, but they weren't Michael Jordan. Jordan was the one, that was the star and made the $30 million. The thing that the analogy I'll use now, because I'm going on a bit of a Seinfeld theme, is I don't know now if Caucus needs to do the preemptive breakup, because how long do they actually really want to stay in this Liberal caucus? And I understand that she had a rather heated discussion with her Ontario caucus colleagues, and so it's now, do you need to break up with somebody before they break up with you?
How tenable is their time in caucus, do you think, Melissa?
Well, it certainly speaks volumes on the Prime Minister. It makes him look really weak. We consistently say that this is a communications problem for the government, a crisis communications for the government, in the sense that they haven't handled it well. It's actually bigger than that. It's a leadership problem, and it's a problem with the truth. And I think Canadians are going to expect answers, because we are still talking about it on week 7.